Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
This is a DOP judge, first time out, there is a waiver on file. We would request a continuance. I have spoken with the state about this matter, and we're providing some of those probation requirements to Mr. Lossmith.
How far out do we want to go?
Just the next DOP cycle, I think would be sufficient.
Okay. We'll do 3/19. March 19th is nice.
Thanks, Jessica.
Thank you. Ms. Graham, did you go out?
Your Honor, Ms. Graham wasn't here earlier, and she said she also has a matter in dependency court with her child, so she's fine.
Yeah, just in case.
Your Honor, if I can, Mr. Hospital, I approach on another matter that's out of docket.
Sure.
Foreman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict.
So, you go by Ms. Andis or Ms. Kennedy?
Ms. Andis.
Ms. Andis, if you received notice for the violation of probation, this is like a new charge.
Yes, sir.
So the purpose of today's hearing is merely to make a plea, and also to inquire to see if you need to have an attorney appointed. Because this is a new case, you have the right to have an attorney on this case as well. 411 will be appointed, it's standard. So my first question is, do you wish to have an attorney appointed, or are you going to hire private counsel? Well, it's always good to, unless this, sometimes the state will have, jump in here, if you're going to say something, say it. If the state wants to offer something.
Yeah, yes, Your Honor. So I was able to pull up my offer sheet, and in this case, the state is offering to modify her probation to add 50 hours of community service. So the state's offering to reinstate her. And if that's something that she wants to do without speaking to an attorney.
Or I can appoint you an attorney, you can talk with the attorney, we can deny it today and come back and deal with it at the next hearing. What do you want to do here today?
So the offer is 50 more hours of community service and reinstating my probation?
Correct.
Yeah.
You want to do that?
Yeah.
Okay, do we need to put that in writing?
Your Honor, I have no problem doing that if she wants to sit,
Okay.
and I'll write it up.
Okay, so we will, state needs to write it up. If you'll hang with us, we'll come back and get it resolved here today.
Okay, thank you.
Okay, thank you very much. And $1,400.
That's mine, Judge.
Mr. Lasco, Mr. Flannery called, he's in Keaton, over in Pensacola, couldn't get over here, doesn't have an attorney. And so he was just freaking out, of course, because he couldn't get a ride over here. How do we want it? This is the first time up for this. I don't know really the basis of the violation. I would suggest maybe go ahead and appoint an attorney so at least he's got somebody to kind of communicate. But I don't know what the situation of the violation is.
Well, Judge, my offer, I was just going to communicate an offer today. The state's just looking to extend for another 12 months so he can graduate from Keaton. So I don't know what the court will do with that commission, but I certainly am not looking for a habeas today.
Yeah. Why don't we go ahead and appoint, because if we appoint an attorney, they can kind of act as an intermediary, whereas, you know, you're probably not going to be comfortable picking up the phone and calling over Keaton to talk with them.
I certainly could pick up the phone, but if the court wants to appoint an attorney, that's fine.
It's up to you. If you're comfortable just doing that, we can just continue this and come back. It's up to you.
Let's go ahead and continue it and come back.
Okay. So we'll continue this matter until, I'm not even going to enter a plea. We're just going to continue it until 3:19 in the morning. Madam Clerk, all of these are in the morning unless we say specifically. The only ones in the afternoon on these miscellaneous things will be sent through the judicial system. So don't do. If there's a question morning, I think it's always the morning. Really important. Thank you. Okay, Nolan Harris. Who's handling this for the state?
That's mine, Judge. I do not see Mr. Harris approaching. This is case number 22CF002676. I have learned from.
It's also, I have 22CF2675 as well.
That's correct, Judge. He might be in jail if the court wants to pass over this. I can double check and see if he's in Okaloosa County Jail. My understanding is he might be facing new charges.
Well, if he had picked up and did, we would have tagged him and brought him over. If he's in the local jail, right? Am I correct in that?
If he's with us, yes.
Yeah.
He's not.
Pardon?
He's not in the county jail unless he got booked. Like,
Well, in that case,
Fully
the state
roster.
requested habeas.
Okay, do we have, when we verify he got proper service for the,
Give me one moment, Judge, and I'll look.
okay. While you're doing that,
I take that back, Your Honor.
I'm sorry?
He got, well, no, that's old. So he's not in jail on this one, that I can tell. At least in our county jail, he might be somewhere else.
Right.
It looks like a notice was sent to him on January 9th, and they had the correct date and time.
Okay.
I don't know if he received it, but it looks like it was sent by the court clerk.
Very good. You asking for a take this?
I am.
We're issuing no bond. Take this.
Thank you, Judge.
Okay.
Thank you.
You want to do the inmates without an attorney, or?
I do have one I'd like to do.
Go ahead.
Sorry, Judge.
That's right.
Chelsea Anderson and then Zachary Dispinette. Your Honor, Chelsea Anderson. Hold on the docket.
37, 22
Thank you.
CF, 28.
For the court in 22 CF 2811. I just learned that the public defender conflicted off due to representation of a co-defendant in 2 misdemeanor cases. I think that, I know that I have to contact my supervisor for a decision on whether it would be best for RCC to have this BOP too. I think it would be in her best interest for me to continue it so we can clarify that issues. Could we do a roughly a month or so.
Sure, we'll continue it to 3/19.
And I'll be contacting my supervisor today. Thank you.
Okay, very good. Thank you, ma'am. Your Honor.
And then I can keep going. Mr. Disponette, because I have.
Then Mr. Patel will get yours.
Steve Medina with Zachary L. Disponette, and
What is it? I can't find it. Is it in your list?
it's one of Rachel Farkas's,
Okay.
but
That's all right.
because I talked to him repeatedly, I probably should have kept the case.
That's
So
all right.
This
That's all right.
one,
I just have to find it. It's under the defense counsel's name. I've got it. Go ahead and announce the case.
Zachary L. Disponette, Dispenette, and 22 CF 745.
Very good.
Your Honor, when he was in court last time, there was a pending out-of-county new law that apparently is the basis for the BOP. I think it's in Sarasota County. They had a continuance because of some discovery issues, but he anticipates that's going to be resolved now in March. So if we can continue this case, when is your court next court date? March 20th. Is there a date after this that the court would be willing to?
You want to do it the March 19th? Does that work?
I think that's a little too early because it's the next day. He's got to be in Sarasota. He'll probably take a probation deal there.
Hold on just a minute. That's the pretrial. April, you want to do it in April then?
That would be preferable.
April 11th,
Thank you, Your
9
Honor.
a.m.
Okay, thank you. All right. Thank you.
Mr. Patel, you want to
Yes, thank you.
do a couple of yours?
I have 4 cases on the docket.
Okay.
The first one, Jay Patel, on behalf of Catherine Anderson, 23 CF 2178. This is a PTI with a plea to a misdemeanor, so the misdemeanor plea would be in absentia.
Is that correct? State?
Yes, that is correct, Your Honor.
Very good.
So, based upon the conversation we had last month, I think I have the process dialed in. So, it's my understanding that the court will sign this plea, the court will e-file it, and then my client will have a control date, and then my client's already sent the packet, the out-of-state packet to Z-Press, and then hopefully the sausage gets made and it'll drop off.
Sounds good.
May I approach?
Thank you. Very good. Thank you. Next.
Judge, what's a good control date?
How far out do you need?
Maybe like a month or 3 weeks, you got a miscellaneous date?
3/19, 9 a.m.
Next, Judge Jay Patel, on behalf of Courtney Baggett, 22 CF 2940. This is a PTI with the plea, same thing as Ms. Anderson.
Okay, very good.
May I approach?
You may. States in agreement, obviously.
Yes, Your Honor, that was the statement.
Okay.
If we can set this for 319 for control.
3/19 as well.
Next, Jay Patel, on behalf of Lawrence Cinco, 22 CF 1299. I believe at this point we're dangerously close to an agreement. I think at this point the terms have been relayed, and I've got to speak to my client, so if we can set this for 3/19, it's going to be a PTI with the plea as well.
Yes, Your Honor, that's the state's understanding, and this week we'll go with Mr. Patel, get that agreement, and we should have something on agreement.
Very good. We'll continue until 3/19.
And then finally, Judge Jay Patel, on behalf of Kenneth Gerard. Judge, I thought we were close to an agreement, that's why I put it on this docket. It appears we're not. If we can put that on the next pretrial.
Okay. Obviously, he's out of incarcerated. He's not incarcerated, correct?
Correct.
So we'll come back. We'll continue. Counsel.
Judge, I might have heard Mr. Patel, did you say for trial?
No, I just said on the next pretrial.
Next pre-trial. Okay, perfect.
We'll come back on 4/8.
And to keep the court informed, our key witness here, the officer who wrote the report, he has enlisted in the military. He was at basic training. We had a tough time getting a hold of him for quite some time. We have gotten a hold of him. He's still in some form of training called AIT. He should graduate at the end of next month, so then we can get our deposition stuff.
Okay. Very good.
I have nothing further to add. Excuse me. Thank you, Judge.
Appreciate it. Have a nice day. Mr. Keach. Please don't knock that coffee on the floor, whatever you got. Who's drinking? Is that Mr. Carroll's? Whose coffee? I'm afraid that's going to end up on the floor. Don't drink the coffee, man. It's perilously, we're going to knock it right on Mr. Losco's back. Mr. Keith.
Good morning, Your Honor.
Good morning.
This is State of Florida versus Mercy and Knox, also known as Mercy and Reed, 22 CF 1305 and 22 CF 1353. And Judge, we set this matter for plea or trial for today. We do have a plea agreement worked out. The plea agreement requires a DOC sentence. And so what we're asking the court to do is one of two things, potentially either allow us to tender the plea and defer sentencing, or just set it off a couple of weeks to enter the plea so that you can get her children squared away before she reports. But if you're able to go to trial, just asking for the court's permission to, and I spoke with the state about it, I heard to tender the plea and defer sentencing, but we're prepared to go either way.
I think I would generally say, let's get as much done as we can today, because things change. So let's go ahead and tender the plea, and we'll set the sentencing at a later date. And make sure she's able to get what she needs to get done.
And so I just need to give the plea agreement to state to sign. Do we just pass it for a minute, or
Sure, that's fine.
let me take care of some other cases? Okay.
I've got the two pro se inmates.
Okay, we'll do the pro se inmates. The first one is
Blackman? Blackman?
This is Blackman.
Black. Okay. Would the state announce, please?
Your Honor, this is State versus Dondre Blackman, case number 15 CF 2266.
So, Mr. Blackman, this violation of probation is a new charge. And so, in this situation, you do have a right to have an attorney appointed if you cannot afford one. You have a right to an attorney, if you can't afford one, will be appointed. You wish the court to appoint a public defender? Okay. Court will appoint the public defender.
Your Honor, Steve Medina for Mr. Blackman. My understanding from talking to Ms. Basso before court in anticipation that he might become my client, Ms. Basso was kind enough to mention that he also has a new law case and that the state might be willing to do some sort of out of custody global offer. I don't think it's over here.
That's correct, Your Honor.
But I don't know if there's been an information filed with the new law.
There has.
There has. Is he on for this afternoon for that? I don't know his next court date on that, but we might be able to work that out this morning if we set him aside.
Yeah, he's not on for this afternoon, Mr. Medina.
let's try and do it this morning if we can.
Yes, could we just set him aside for a few minutes?
Absolutely. I thought you were asked for this afternoon.
Oh, no.
Jam this afternoon, so.
No, Your Honor, just a brief break this morning with him, and then I'll get with Ms. Vaso.
That's fine.
All right. I'll be with you.
This one.
Sure.
Let's give one more and then we'll.
Taylor Dixon.
This is one without.
Hold on. They're gonna bring it back out this morning.
Excuse me, this is Taylor Dixon. He's actually my client. I appeared with him last week. This document is 2024 CF 0032. Mr. Dixon took an offer. He had 4 VOPs, and this charge, I'm not sure if you remember, was meant to be a part of that offer, but there was miscommunication. I missed an email, and our office hadn't yet been assigned. So we have a resolution for this case, which will run concurrent with the 4 resolved VOPs. If I could approach. Oh wait, I'm sorry. He has to sign it. We have discussed this offer at length, Your Honor.
And who for the state's have witness? State's in agreement?
Yes, state's in agreement.
Mr. Dixon, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court, the truth, nothing but the truth, so help you God?
I do.
Okay, so I'm looking at your plea agreement, and as your defense counsel stated, there'll be an adjudication of guilt on the 3 counts, and the drug offender probation will run concurrent with your current probation. So same things that applied to the earlier ones apply now. You're waiting tonight to go to a trial on this in order to resolve this. Have you had all your questions then? Do you understand what's going on?
Yes, sir.
Okay. And you're wanting to take this plea and have it run concurrent with the other cases that you've got?
Yes, sir.
Okay. Very good. So the court will accept the plea and will adjudicate you guilty on the 3 counts, the underlying counts, and sentence you to 12 months and 1 day drug offender probation to run concurrent with your current modified probation. Okay?
Thank you, sir.
Thank you. Mr. Each?
All right, yeah, we're back on the record with Mercy and Knox, 22 CF 1305 and 22 CF 1353. We are going to tender a plea in 22 CF 1353 to counts 1 and 2. By agreement with the state, a condition of this plea would be that 23 CF 1305 would be dismissed, as well as count 3.
Do you have an extra copy? So
I'm a-
just look at it while you're. Thank you. Go ahead.
And Judge, we're pleading no contest in 22 CF 1353, and we're asking the sentencing to be deferred for a couple of weeks, or approximate day or two, so Ms. Knox can get her affairs in order, specifically her arrangements for children. And I have explained to her that if she failed to appear or picked up new charges, her plea of no contest would stand in the terms of the plea to be left open, or the terms of the sentence would be left open to the court and the state.
Say that again?
That if she has to appear, that her failure, if she fails to appear, or if she were to pick up new charges, the plea of no contest would still be a valid plea of no contest. But the sentencing could be altered.
Correct. Terms of the agreement could be altered.
Could be altered.
Okay. You understand that, ma'am? Would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes. I know that this case has been lingering for a while, and I'm sure you've had numerous conversations with your attorney, so I know you're more aware than some are on this situation. Mr. Keith, you may continue.
Judge,
You want to you want to make sure that she's aware of what she's going to be sentenced to?
Certainly.
And, even though we're not sentencing today, we're going to tender the sentencing out, but I want to accept that she understands what's coming.
Yes, sir. The agreement with the Office of the State Attorney would be that Ms. Knox be pleading in count one to a lesser included offense of sale, manufacture, deliver of a controlled substance, second-degree felony, and count two, possession of a firearm by convicted felon, constructive possession, also second-degree felony. The terms of the sentence would be that she'd be adjudicated guilty, sentenced to 18 months in the Florida Department of Corrections on each count, followed by 3 years of drug offender probation. She would receive credit in each count for 481 days, that is day-for-day credit, from the date of arrest to the date she bonded out on September 12th of 2023. The 22 CF 1305 case would be dismissed as a condition of this plea, as well as count 3 and resisting an officer without violence in 22 CF 1353. Standard fines, costs, and fees would be imposed of $615, fines and costs, plus $150 legal assistance fee.
Okay. So, Ms. Knox, is that your understanding of what the agreement is, the plea agreement? Yes. It's a stated agreement.
That's correct, Judge. I should put on the record that the FDLE report came back as not fentanyl, instead it was cocaine. I will file an amended information before sentencing that will say sale, manufacture, deliver cocaine.
Okay. Very good. So you understand, you want me to go by Knox or Reed?
Knox.
Ms. Knox, you heard the terms of the plea agreement. We're not sentencing today. Normally I just roll right into sentencing. We're not going to sentence today. Give you a couple weeks to get your affairs in order. But the terms of the agreement are set. Do you understand that? Okay. You understand that by entering into this plea agreement, you're waiving the right to go to a formal trial and you can test all these things, force the state to prove their case beyond reasonable doubt. You believe this is in your best interest to enter into this agreement? This will be a final adjudication except for the sentencing here today. You believe yeah. Importantly, I see you've signed the plea agreement. Have you gone over it? I assume you have, but I'm going to ask you just for the record. Have you gone over it in detail with your attorney? Make sure you had all your legal questions answered?
Yes.
Okay. Do you believe this is in your best interest?
Yes, sir.
You sure? Do you have any further questions of your attorney regarding this plea?
I was just worried about the 481 days. Because that's critical time service.
What do you mean you're worried about?
16 months. I did my time.
Okay, this actually stipulates to 481 days. I didn't understand your question. You said I'm worried about, in what way are you worried about?
Because I did.
You're worried that they're not going to give it to you even though it's in here, or you're worried that it's actually more than that? What is your question?
I was just saying, like, I just wanted to do probation because I did my.
Okay, that's, we're off.
Okay.
One thing you understand enough to know, that this right here is an agreement between you and the state. I'm not involved with it. I'm just kind of overseeing it. This is between you two. Even if I wanted to, I couldn't jump in the middle of it, okay?
Yes, sir.
So, are you satisfied with this deal and you want to go forward with this deal?
Yes.
Okay. Even though you'd rather something else be there, I understand that. Whenever there's a deal, it's always the state gives up a little, the defense gives up a little. Nobody gets exactly what they want. That's generally the rule on these deals. You're comfortable? Okay, very good. court will accept your plea sentencing agreement, if we haven't scheduled time for the sentencing.
No, Your Honor, and just for I'm unavailable the 15th to the 19th of March. Is there
The 14th.
the 14th?
You got the 14th?
Yes, sir.
Okay. You want to do it the 14th?
Yes, sir.
We can do it in the morning because the sentencing itself will be short.
Yes, sir.
We'll do sentence on 3/14/19.
And I've provided her a court notice for the date and time.
Very good, thank you.
All right.
Good luck. Okay. I'll give you this back. It might be for some other court.
Mr. Burns, that came from, I mean, the message to you.
He's not going to knock.
I don't know
If he shows up the last.
I think it's Mr. Burns.
Your Honor, Steve Medina with Jamari Bush, B-U-S-H, in 19 CF 1059. Mr. Bush, obviously, he's out on bond. I had him as in custody. But if we could continue his case, he's got, I think, a misdemeanor driving case that might be an open case, but in any event, I need to meet with him now that he's out of custody and go over the situation. If March is fine.
Okay.
Not March 14th, because I know I'm out of state.
Continue March 19th. At 9 a.m. in the morning.
Okay. I didn't miss it. I was here. You're fine. You're fine.
Just will make sure you find it.
I'll call you when I leave.
Call Aaron. Call Aaron. When you leave.
Okay.
Thank you.
Thank you. That's it?
Yes, sir.
Have a good day.
Thank you, you too.
Mr. Patel, do you have business?
No.
Mr. Keach, are you? I'm all done. You're done? Okay. So, Nolan Harris, who we issued a case has arrived. Mr. Harris, are you here? Nolan Harris, come forward to the podium. Do you know court started at 9?
Yes, sir.
You were issued a case, somebody was going to be coming looking for you.
Yeah, I know. I had to get it right here. I apologize. I really do.
You don't have to apologize, just get here on time.
Yes,
Get
sir.
priority. You've got a lot of people.
I did everything I could to get it right, even if I had to walk.
So, okay, so would the state announce the cases?
This is State versus Nolan Harris. Case number is 22CF 002676 and 22CF 002685. These are two violations of probation. If Mr. Harris would like to resolve this today, the state's offering to modify his probation to add 6 months, and he would need to complete the original terms.
So we can do one of two things. That offer has been made, it will stay open if you want to do it. You don't have an attorney appointed at this point, but if you wanted to, the court, and you could not afford one, the court would appoint an attorney, enter a denial on this, allow you to talk to your attorney, come back, see if if you want to take the deal. So nobody's trying to force
And
the deal on it today.
I
but
totally understand, Your Honor.
What would you like to do?
Can I present documentation to the state, please?
You want?
What he's handed me is a certificate for completing the Irish intervention program. The problem that I have is that Probation came over and reported us that he might have new charges. So that would affect the state's offer. I can't, well, I'll give this back to you. I would ask the court to continue this, that way I keep more information from Probation, because that would affect the state's offer.
So, Mr. Harris, do you wish, you want to have, we're going to continue this time. You want me to appoint you an attorney? Then you can talk with him and find out what's going on here. Apparently, there's maybe some things in play here.
Well, what was the original offer before about the 6 months?
I assume you're withdrawing the offer.
That's correct, Judge. Based on what Probation just came over and told me.
There may be some new information that the state is becoming aware of, so they're not going to make an offer today. They don't have to make an offer, but they probably will in the future, but they've got to figure out what's going on.
I'm going to find out.
Yeah. So what do you want? You want to have an attorney appointed? We're going to continue this matter to March 19th.
And Judge, can you recall that habeas?
And the cases will be withdrawn.
Thank you.
Thank you for reminding me. You want me to appoint an attorney, Mr. Harris? Don't have to, it's up to you.
Your Honor, I really would just want to just...
It's not going to be resolved today. The matter's being continued to March 19th.
Okay.
They can't resolve it because they don't know what the facts are. They're getting new information. They got to check into it. They're not going to just operate willy-nilly. You don't want that anyway. Okay? They need to figure out what's going on, and you need to figure out what they know as well. So until we get all that, we can't take any movement. We'll continue it to 3/19. You want an attorney?
Yes, Your Honor.
Okay. Or we'll appoint the public defender. Who would get Mr.
Would be Mr. Gates. I can give him a card and
We'll
I'll.
get you a card so you can communicate with him, okay? 3/19 at 9 a.m.
Thank you, Judge.
Want to do Hillary Harshfield? You want to do that or you want to? That's one of the inmates that was out in Thursday.
I showed her, she's appointed Mr. Gates.
Okay, then we'll pass over this. Mr. Harper, you want to do something?
Mr. Harper, Judge, mine are all in custody. I don't know if the court wants to clear out.
That'd be fine. Ms. Farkas, you want to do any out of custodies?
I don't believe I have any.
I'm looking at.
I forgot, sorry.
Brittany Cinco.
Oh, no, I'm sorry.
I think I kept Cinco.
Want me to do Cinco?
I will keep Cinco.
I filed a paper.
Okay, Medina, would you change that from who's representing? Brittany Cinco?
Yes, C. Medina for Brent D. Cinco. My colleague filed a waiver. Did you talk to her too?
Yes, Your Honor. I spoke with her. She just had surgery and is unable to come to court today, so I filed a waiver.
Okay.
I'm sorry, I have additional information in my
Okay.
file, because I didn't know she was on the docket. Judge, her husband is a co-defendant represented by Jake Patel, who's just here. He just asked me to continue this. There we go, Jake, how long should we continue this? March 19th. Can we continue Brittany Seco to March 19th?
Yes, we'll continue it to 3/19, 9 a.m.
Thank you.
Your Honor, this is Alan Cheatham. Docket 2024 CF0141.
How do you spell that?
CHEATHEM.
CH?
It's set on the pleaded docket for this afternoon, not this morning's docket.
I just realized that I think he's on the 130 docket.
Okay.
If there's any way that we can call his case now.
Okay. You gotta let me know, we actually run with organized dockets here.
I apologize, Your Honor.
We don't just run.
I apologize, Your Honor. So this is Mr. Cheatham. We'd like to enter a plea of not guilty.
Very well, the court will issue or accept a not guilty plea, and we'll continue this to the next pretrial, which is 4/8, April 8th at 9 a.m.
Thank you, Your Honor.
Who needs a copy of this information?
I think that's the only non-inmate you have for this morning. Well, I've got Michael Evans.
He had a case on last week, Your Honor, and there was a habeas issued, so I need to check. I'm not sure if he's been picked up.
No.
No, he has not been picked up, so I don't have any information as to his whereabouts.
State, let me announce, 22 CF 67, what do we need to do here today?
Your Honor, the state would ask for cases.
You already got a case, we need to know. Madam?
I'm sorry,
Mike,
no, we don't, she was just moving. No, we do not need to communicate this, I apologize.
So we want to continue this? I mean, just keep it on the books?
Yes, Your Honor, that would count.
Okay. 3/19?
Thank you, Your Honor.
Your Honor, so we're not issuing tickets for this case?
That's correct. He already has a case issued.
Not for this particular case?
Not for this case. The state says they are not requesting cases on this case, correct?
That's correct.
Okay, so that's all I've got for non-inmate for Ms. Harps.
Thank you, Your Honor.
There's more. Ms. Redina, you want to try some?
I don't think I have any out of custody, Your Honor. Not aware of any.
Okay, well, let's start with in custody. Mr. Harper?
Just judge up this morning's docket. If we could pass G briefly, because I think the state just needs to talk to someone, we might have to stipulate to a bond.
I'm having the mails come out now, so.
Copy that.
Yeah, just hold that on G. Clark, okay, good talking.
Judge, this is Antonio Clark. His number 17 on the docket. Before the court on 23 CF 2098 and 23 CF 2050. He's before the court this morning on a motion to set bond. His bond in 23 CF 2050 is revoked. What's pertinent here, Judge, is that the alleged victim in the case 23 CF 2050 has requested the charges be dismissed. She in fact filed something pro se or third party. And basically she stated that she fabricated the gun allegations, the battery assault allegations. She was angry at my client at the time and basically wrote these statements while she was impaired. So it's our argument today that we are asking that the offenses pertaining to the alleged victim be converted to signature bonds so that we can contest the validity of those actual allegations, and that his previously revoked bonds be reinstated.
So
the victim, her statements, I believe it's in benchmark November 13, 2023.
State?
Your Honor, the victim did do a pro se filing to the court and also provided an input form to my office, which is when provided to Mr. Harper, that said essentially what he just said. However, Mr. Clark still was out on bond in the 23 CF 2050 case when he picked up the 2098 case, and the state is still going forward on possession of a weapon or ammunition by a convicted felon, and the driving while license suspended, the habitual traffic offender charge, Your Honor. The defendant, even without the aggravated assault charge or without the felony battery charge, still scores for prison. He has a prior battery on a law enforcement officer. He has 4 prior claim or attempting to elude a law enforcement officer, 1 prior aggravated assault. He has with 1 prior aggravated assault with deadly weapon, 1 prior aggravated assault on a law enforcement officer, and 1 prior resisting without violence, Your Honor. We do believe it is appropriate for the bond to be remain revoked in the earlier case, and the state will proceed without the victim in the new case. The state does believe that Mr. Clark bonds are appropriate, and that revoking the bond in the earlier case is still appropriate.
As to just the issues, the aggravated assault and the felony battery that the victim is seeking to changing her story or whatever, is the state proceeding with those as well?
No, Your Honor, the state will be proceeding with the possession of an ammunition or a weapon by a convicted felon in the driving charge.
Okay. And what is the bond for the ag assault and the felony battery?
Your Honor, the ag assault is 5,000 cash professional. The possession of a weapon in that case is 5,000 cash professional.
Felony battery.
3,500 on the felony battery and 1,500 on the driving suspended. Your Honor, if I may briefly just respond with what you said. 23 CF 2050. His charges in that particular case, for which his bonds are revoked, are aggravated assault with deadly weapon, possession of weapon or ammo by a convicted felon, felony battery, and driving suspended. Of those 5 charges, the victim in this case.
I'm sorry. I'm looking at something different than we say that again. 2050?
2050.
I just have 2 charges, and neither one of them are what you just described.
You're right. You're right. The driving suspended and resisting arrest is 2050. Okay. 2 charges, 23 CF 20.
And I've got 4 charges in 2098, not 5. 4. I've got ag assault, possession of a weapon, felony battery, driving on suspended vigil.
Yes, sir.
So there are 5th?
No, the 4.
Okay, so I got the right. Okay, go ahead.
Out of those 4 charges,
and that's the basis, the fact that those were filed was the basis for revoking the earlier law.
yes, sir.
Okay, I'm
And-
following, so I just want to make sure I got my facts right.
Correct, Judge. You're right, I misspoke.
Okay.
Of those 4 charges, 3 of which arguably were manufactured by the victim, at least according to her statement. But for her statement, there would not have been a BOLO for the driver suspended, and arguably he may not have got that particular charge either. And if not for those actions by the victim in this matter, his bonds in 23 CF 2050.
So which of the 3 would?
The aggravated assault, possession.
I got the ag assault and the felony battery. I understand those 2, and how she's saying that didn't occur. Is it possession of a weapon? Is that?
Yes, Judge. The argument is that she stated that he was in possession of the weapon when he made the aggravated assault. That's why it's aggravated, Judge, for this allegation.
Is that the
Well-
sole basis for that charge?
For the aggravated assault charge?
No, for the possession of a weapon.
No, Your Honor. So the deputy actually went into the defendant's residence where a 9mm firearm and 2 loaded magazines were located in a dresser in his bedroom, and also during the inventory of his vehicle, the holster for that firearm was found. So that is the basis for the possession of a firearm by a committed felon.
And Your Honor, in that statement that she wrote, basically what happened is that she obtained keys from law enforcement. She entered into a residence which she had no authority to enter into. She didn't live there or reside there. Entered into the residence where he doesn't reside alone. There are other occupants of that residence, and grabbed a firearm that in fact does not belong to him, it belongs to the roommate, and then produced that as evidence of the firearm in question. In her statement, she also recants that particular issue, saying she didn't have authority to go in there. Notwithstanding all that, Judge, we are asking for signature bonds with respect to those offenses and reinstatement of his bond in the previous case.
Well, based upon the 2 charges that are not going to be pursued, the court will, on the ag assault and the felony battery, the court will grant the request to make those signature bonds. As to the remaining charges and the bond, the court's not altering the bond, and the court is continuing to revoke the earlier bond because there's a new law charge common to revoke the bond. You're out on bond, you're kind of on special. It's a special accommodation. If you pick up another charge, more often than not, they will revoke that bond. So the court's going to continue to revoke that bond. Good. Thank you very much.
Hey, yo, can I put in for a pretrial on this? Like, why was she
We're here on bond here.
6 months?
If you want a speedy trial, file something.
Oh, man, I've been putting motions in.
Sir, we're here on a bond here.
Judge, this is Michael Costin, speaking for the courts on 23 CF 1401 and 23 CF 1402. The court may recall that yesterday it entered the uncompleted bench. That would be capped at 12.1 months concurrent on all charges. He is asking for sentencing by the court. We're ready to proceed forward to sentencing people today.
I'm just wondering whether we need to put this off until later in the morning, or we can.
We can, Judge.
It's going to take a little more time. Let's try and do this.
And Judge, I would ask to pass my other case, Kathleen G. State is going to inquire about something. We might be able to have a stipulated bond this morning, Judge.
Very good.
Can I approach the clerk?
Sure. Ms. Graham, you want to, I think you got here before Mr. Tony.
Yes, I'm right there.
Come on.
This way on the charges.
Oh, we're at still.
But, Your Honor, she asked me to look at something that I don't know.
That's all right. We'll just pass over. That's all right. Mr. Tony, you ready to go?
I'm sorry. Good morning, Judge.
Good morning. not ready, we can go if we get sufficient.
I think we're not gonna be ready on, I think we have Shea Patrick Jones on this particular case, and he's a federal inmate at this time.
He's a
had been
federal
trans-
inmate?
Yeah, he had been transferred, but we didn't do an order.
God, says he's in the county jail.
Which one name?
Shay Jones, the senior?
I believe it says other institutions.
It's other institution there.
Oh, really? It says county jail.
Yeah.
Anyway, that's all right. I just, if you were just here for some
Yeah,
reason.
we have an agreement in principle, I think, but it's just a matter of getting him here before the court, so, sure, we're not.
What should we do? I mean, I don't have a problem with continuing it, how far out,
I think we just need the next miscellaneous date to get him here.
so we'll just continue to 3/19 in the morning, and
Make sure.
that's sufficient time to get him in the order to transport and all. I know with the feds, sometimes it's a little trickier.
Your Honor, may we approach?
Sure.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
22 CF 1104.
Just checking. I'm gonna see if the judge needs to take a recess.
11, 9 a.m.
That's all I have, Your Honor.
Thank you.
And that concludes my business with the court. May I be excused?
Yes, ma'am. Thank you.
Your Honor, I have a Mr. Coney as well.
I'm sorry?
I have defendant Brian Cohen with Mr. Coney, said on the docket. That's correct, Your Honor. That's our 2:30 sentencing today.
I'm sorry?
Mr. Cohen is our 2:30 sentencing.
2:30, yeah. Sorry.
Do you mind if you send that back to Mr. Blackman, sir? I didn't understand that. Sorry.
If you announce the case.
Yes, Your Honor. Good morning. Tricia Graham on behalf of Crystal DuBois, who's here for a violation of probation in case 20 CF 1364. Your Honor, we've reached a resolution to this case. Ms. DuBois provided additional proof to the state. At this time, we'd like to plead to admission to the violation of probation as to counts and the allegations of 1, 2, and 3, not 4. And there are 2 counts in that case. And at this
Do you
time,
have an extra copy of that where I can track while you're reading?
I approach with that.
Sure, sure. I mean, do you have something you can read off?
I know what it is. Thank you, Judge.
Okay. Very straightforward. Go ahead.
And at this time, the agreement is to be adjudicated as to the violation of probation, receive credit for her time served, and terminate probation at this time. And we will convert the remaining outstanding court costs and fees, as well as restitution to a judgment.
So for each of the 2 counts, it's credit for time served?
Yes, Your Honor, that's the case itself. She was on probation for the false information to the pawnbroker and the grand theft. So those would be the two charges.
And then we'll terminate probation.
Yes, and the violation of probation affidavit lists 4 violations. We'd be admitting to 1, 2, and 3, not 4, as the 4 was the anti-theft course, which she provided a certificate of completion of that.
That's accurate.
Very good. And there's an adjudication of guilt on the underlying charges.
Yes, Your Honor, there was previously an adjudication as to this case.
Okay. And generally speaking, on the as to restitution, can we give them some time to do that? I know we can on the cost. You wanna give your client 180 days before it goes to
Judgment, that would be
because
great.
it will-
The state doesn't object to that.
It's $220 with me.
Well, the reason for that, ma'am, is that if we go to judgment, they could go after your driver's license.
Yeah.
So give you 6 months to pay the cost and fees and the restitution, so it won't impact your driver's license, which is an important document around here.
Yes, sir.
So I'll put 180 days to pay costs, fees, restitution, and then convert it to a judgment.
Then goes to judgment. Very good.
Thank you, that's perfect.
Sure. Mr. Boyd, is that how you pronounce that?
Dubois.
Dubois. Would you raise your right hand? Do you swear or affirm the information you're about to provide in support is the truth, nothing but the truth, so help you God?
I do, Your Honor.
So you heard that your attorney state the terms of your plea agreement, and I was looking at it and saw that the written plea form contains the terms as well, and you signed it. Have you gone over this, the terms of the plea agreement with your attorney?
I have.
And understand that this is a final resolution of these violations of probation?
I do.
You're waiving the right to go to a trial and
Yes, sir.
contest these things, and you want to have a final resolution today.
Yes, sir.
You believe it's in your best interest?
I do.
I would agree. Therefore, court will accept your plea agreement here today. You'll get credit for time served, and the court will terminate probation. And you'll have 180 days to pay all current costs, fees, and restitution. And then it will go to judgment after 180 days if they're not paid.
Yes, sir.
And there will be an adjudication of guilt on the underlying charges.
Yes, sir. Thank you.
Good luck, ma'am.
Thank you. Thank you.
Thank you, Your Honor.
Thank you.
May I be excused?
You may. Mr. Gates, you want
I can take a couple, Your Honor, if the court will give me a second. I can't run my list because I do have a couple that I need to send plea agreements back. Which I'm.
That's fine. We'll do it what you've got available, and then we'll take a morning break, and we'll kind of give everybody a chance to kind of finalize some of it.
Yes, Your Honor. If I can take Justin Hammett. And after Mr. Hammett, if we can do Calvin Johnson.
Hammett is downstairs in misdemeanor court at the moment.
Then we'll take Calvin Johnson
Then I'll take 35
and Raymond Coon.
and 36. Hammett might be coming back up.
Johnson? You know, this is going to be Calvin Johnson before the court. Grab my paperwork if I can. He's before the court 18 CF 917, 18 CF 1249, 20 CF 1621. We were hoping to get him approved for Keaton portion of that did not go through. Speaking to the state, we're going to ask the court to.
Counsel, would you repeat those, because I've got different.
Different numbers? I have 18 CF 917,
Okay.
18 CF 1249, 20 CF 1621.
Great, yeah, thank you.
We need to continue Mr. Johnson's case without subpoena, or without subpoena, Your Honor. We are looking at some alternative inpatient programs at this time.
Do you want to go out about a month?
Yes, Your Honor.
319 works?
Yes, Your Honor.
Okay, so we'll continue this matter till the 319 in the morning, without subpoena.
Thank you, Your Honor. This should be Mr. Boone, number 33 on the docket. We have a plea agreement to be filed in this case. And Your Honor, Mr. Kuhn is originally sentenced to misdemeanor, so there'll be no score sheet on this. Okay. And Mayor Brooks? Thank you. John?
Will you please announce the plea?
Yes, sir. Mr. Kuhn will be admitted in violation before the court in 19 CF 721. Be adjudicated guilty, revoked and terminated his outstanding probation, sentenced to 6 months in the county jail concurrent between both counts with credit for all time served. States also agreed to additional credit from Santa Rosa County Jail from January 16th to January the 30th, 2024. $100 cost of prosecution, $150 defender fee. Mr. Kuhn would ask for 24 months to pay those outstanding fees from his release date.
That's correct, Judge. Mr. Kuhn, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes, sir. So you heard your attorney state the terms of the plea agreement. Is that your understanding of what the plea agreement is? Yes, sir. I see you signed the written plea agreement. Have you read this closely? Gone over with your attorney?
Excuse me, bless you, Your Honor. Yes, sir, I have.
Okay. And you understand that by entering into this plea agreement here today, you're waiving your right to go to a trial and some other valuable legal rights. You believe this is in your best interest?
Absolutely.
Here today?
Yes, sir.
And you understand this will result in a 6-month jail sentence, although you do get credit for time served.
Correct.
Bless you. So, based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt on the underlying charges, revoke and terminate probation, and the defendant will be sentenced to 6 months in the county jail on each count. It will run concurrent. You will get credit for all time served. State agrees to an additional credit from your time in Santa Rosa County Jail from January 16th to January 30th, 2024. And there are fees and costs, and court will allow 24 months from the date of release to pay court costs before they're sent to court. Okay?
Thank you.
Thank you.
Thanks so much.
Do we have Mr. Hammond up here?
No, they just said that they're holding him downstairs too.
I think at this point, I will get a recess.
Okay. Yeah, let's go ahead and take that.